All right. I was gonna wear my headgear. People were expecting a brawl.
Nah, man. Holy cow. How are you?
Good, man. I think it's important that we do this. And I think a few things we have to speak about when it comes to this. Number one, I remember hearing about this. I don't know if it was one of the websites posted like an instructor spiked a student on their head. The student was awarded $46 million. And when I read that, I was like, man, like, and they didn't even say student, they said a beginner student. So I was like, man, what kind of instructor spikes their beginner student on their head? Like, what the hell is this, right? So I had this preconceived notion of what happened in my mind. I imagined somebody, like an instructor, getting irritated with the student. Maybe the student gave him like a tough time. I imagined the instructor shooting in, lifting the student, and like pile driving him on his head, right? And then I read your statement, and I didn't think much because I still, in my mind, was thinking that the instructor shot in, lifted the person, and spiked the student on their head. And then I saw the video, and it just didn't look like that whatsoever, right? Like it was a totally different scenario. And we'll get into what you did, the spiked thing too. So when I first saw that, I was like, man, like this is not what I imagined happening at all, right? So I was just like, what is this? And then I watched it again, and in my mind, you're right, I didn't notice the arm was trapped at first, because I actually put on a video that day, like, oh, here's an easy way to escape it, and then you put your video on, and I was like, shit, I didn't realize the arm was trapped, right? But I thought that the student may have initiated a Granby roll, right? Because we could Granby from that position. But like just so everybody knows, my biggest issues real quick, I'll go down the line with Rener, were number one, $46 million. And I'll let Rener answer all this. I'm like, Rener, $46 million. Like I messaged him immediately. I DM'd Rener immediately, and I was like, bro, like, I got love for you, but what is this? This is crazy. Number two, I didn't like the term spiked. Number three, I thought it was a total accident. Number four, I thought he initiated a Granby roll. Number five, I didn't know they tried to settle, right? Am I missing anything that my issues that I had?
No, those were what you communicated.
I'll hand the mic to you. Go ahead.
Yeah. Yeah, for sure. The 46 million, and you can, I'll let you speak for yourself on this one, but what was your assumption of how that number was arrived at?
I thought it was like you being like, yeah, you know what, like he deserves $46 million. And I was like, bro, what the fuck? Yeah. You know, like it was crazy.
I feel like, Tom, the jiu-jitsu community, there are other people who feel that same way. As if I got involved in this. I had to say,
most people do. Most people do think that you had something to do with it,
and
right?
It was a shock. When you told me that, I was shocked because I had not anticipated that people had associated me to that number as if it was my doing, like my choosing. And listen, I can't be upset about what people know and what people don't know, really, because people simply don't understand the legal system. So for many people in jiu-jitsu, this is their first exposure to this type of proceeding or this type of process taking place. So it's not a crazy surprise, I guess, and especially seeing how much anger and frustration there was associated to that settlement or that payout, that people think what you thought, which was Rener went in there and was like, yo, he got hurt like this. He should get $46 million. So I was happy that you gave me the chance to talk about that.
You were shocked. When I said that, you were like, what are you talking about? You're like, I had no idea.
I was blindsided by that. So just so people know, Tom, and I'll kind of reiterate somewhat of what I told you, is that at no point during this process ever did the attorneys ever even ask me, A, if he should get paid out, or B, how much he should get paid out. There was none. And throughout the entire process, not once did they disclose to me what they were pursuing. Even during the trial, the witnesses are all isolated and kept away from each other. And they don't say, this is the amount we're going for. Now, that's not my area of expertise. That's doctors, life compensation experts, all the other experts they brought in make a decision, and then the jury ultimately decides what that number is. So when the number came out, I was as shocked as all of jiu-jitsu that it was that high. And like you said the other day, you were like, man, Rener, I think you should have got paid, but that's kind of a ridiculous number. That was what you said. And I'm like, I didn't really have a vote in the matter. I had no knowledge of it. All I knew, Tom, was that they tried to settle with the insurance, because I said, guys, what about the insurance for the school in the very beginning? And they said, Rener, we went to the insurance, which had $1 million policy limit, and the insurance policy said take a hike. Basically,
well, that's something we needed to talk about too, because here's the thing: no matter what's, I think everybody agrees that this kid deserved something, because he was paralyzed for how long was it?
Exactly how long, I don't know. I know immediately he lost all function, but he's now quadriplegic and will be that for the rest of his life, essentially.
And I think what happened too, like his Instagram wasn't private, right? And it showed him hiking up mountains. So when you see, oh, wait a second, this kid, we're told he's paralyzed, but now he's hiking up mountains. Now, I don't know what kind of equipment he's using to help himself hike up or whatever. And God bless him, we all want him to be well, right? But at the same time, I think a lot of people thought, like, wait a second, like, something's wrong here, But since he was paralyzed for an extended period of time, couldn't work, like, this is why we do pay martial arts insurance, right? This is why we do have insurance. So the martial arts insurance, that's like getting in an accident, in a car accident, and then you're Geico saying, hey, man, listen, it wasn't your fault, it was their fault, so it is what it is, we're not going to cover you, right? So that wasn't fair, like it shouldn't even have went to trial. Yeah, it should have just been settled at $1 million.
Listen, and that's kind of what, in retrospect, if we look at it now, the poor decision making by that insurance company, Tom, is probably one of the biggest lessons I learned. Because remember, I was only involved as a participant, as an expert witness, jiu-jitsu guy, but I'm just watching this whole thing play out, and I'm like, man, what are the implications just for me? And what I now understand is that when the insurance company decided they weren't going to settle within the policy limit and say, sorry, we're not going to do this, it gave Mr. Rener no choice but to pursue compensation through the legal system. It opened up everything, and the level of exposure that the insurance company put on the school owners in that decision is astronomical. Now, from what I understand, that $46 million is not coming from the school owner and Iteralde. It's coming from the insurance company, and they're going to go seek that money from the insurance company who made the mistake of not settling when they had the chance. That's my understanding of it. But nonetheless, they should have solved this right up the front. And like you said, if we don't have insurance for issues like these, then the question is, what is insurance for?
Right.
What are we doing?
And it was a freak thing, but the thing is, we do know there are injuries in jiu-jitsu. That's just going to happen, right? This was a freak thing. Like I've seen people land on their neck in worse positions than this, right? Especially in wrestling competitions and everything, thinking they were going to, I mean, geez, remember Fedor versus Randleman, right? Again, they were pro MMA fighters, is a little different, but I think this was a freak thing. However, if somebody is taken out of work for an extended period of time, our insurance needs to step up a little bit.
You know what it is, Tom? And I think what it is too is the public's misunderstanding between, intent and accidents happening, and then just liability, right? Like there can be an accident that happens as a result of your action, and you still be liable, or you still be deemed responsible in that situation.
Now that's something we got to get into as well, right? The Granby rule.
Sure.
I was floored when you told me this. Like, I also thought that you were basically saying, like, listen, it's 100% of the instructor's fault. Like, I was expecting the instructor to say, no, he did initiate a Granby roll, and I just went with it. And I expected you to be arguing that, no, he didn't initiate a Granby roll. It was your fault, your negligence. But when I came to find out from you that he never, ever, ever he had no defense, right? Like, he didn't say, his defense was jiu-jitsu, right? Like, that was it.
Yes. So here's what's wild is that, as far as I know, there was no testimony in the lead up to the trial that a Granby roll was attempted. But what I do know for a fact is at trial, the judge actually decided And based on the input from both parties, the plaintiff and the defense, this is important because this Granby rule, Tom, it came out of nowhere. After this release, people started saying, yeah, but what if he went for a Granby rule? And it went from what if he went for a Granby rule to he went for a Granby rule, so therefore he caused it. And then people started taking that headline on MMA or BJJ websites and that kind of bullet point, and then writing about it and publishing it as if it were a fact that a Granby rule was attempted. So then I went back to the trial transcript and basically regarding the Granby rule, there is a quote here regarding right here. So this is at trial regarding the Granby rule. The judge, this is during my trial testimony, a question was asked of me, and then the judge interrupts the answer with this, and I'll tell you here. The question was, the proper way in which to address this type of move is, would you say, an experienced artist would be to tuck one's head, correct? They asked me that. The judge interjected at this point, it says the court, and it says, Mr. Rener did not do anything wrong. His negligence is not something for you to consider. So ask another question, please. He told that to the attorney. So it was established, Tom, during the trial that Mr. Rener had no involvement.
This is where the instructor needs a better lawyer, right? Like, or the insurance company needs a better lawyer. And also, are we able to talk about when Clark was asked if he would teach the same technique?
Yeah, so the answer is we can talk about it. And from as far as I know, and for the public listening who doesn't know, the expert witness on the defense's side for Mr. Iturralde, the expert witness in jiu-jitsu was Clark Gracie, my second cousin. Very talented, very successful school owner, has his own affiliation, and has done great things in jiu-jitsu as a competitor and as a teacher. So they retained him as their expert. And, you know, again, his deposition, he has it, and, you know, people can find that as well. But generally what was said was that when asked if he teaches the technique this way with the arm trapped, Clark said that that's not how he teaches it. And they said, well, do you teach it over the shoulder in a conventional seatbelt capacity? And Clark said, yes. And they said, why? He says, well, it's safer and it gives more direction to the technique.
Yeah, but right there, that's a showstopper right there, man. You know, like if that's your own defense, you know, like, and I hear what Clark is saying. I get it. You know what the issue is, though, Rener, like beyond all this is like, I don't know if you said it or somebody else said it. Somebody said you should never initiate a technique that you cannot stop at any time immediately, right? So then my question is, what kind of flying techniques could we ever do, right? What about any takedowns once we lift somebody, any mat returns? No, I don't allow mat returns on my, just so you know, like if somebody stands up and their back is turned and somebody wraps their hands around their waist, I do not allow the person to jump on their back or either to lift them and bring them back down, because I've seen injuries occur that way. But the whole thing is, we say that Iturralde didn't execute the technique perfectly, and my argument to that is, when is anything in jiu-jitsu executed perfectly, right? This is why we train. Like, the same reason why some people quit in jiu-jitsu is the same reason why some people flourish and love it, because it's just, it can never be perfected, right? But guys, like in my mind, I think I could perfect it. I'm sure in your mind you think you could, but we're never hitting the perfect move. It just so happened when he didn't do it perfectly this time, a huge accident occurred. So that's my question to you. Like, what is your response to that?
Yeah, great question. So they asked me, you know, in deposition, they said, Rener, what about asking a technique? What about, when do you know when to do a technique safely? What's your criteria for determining that? And this is my response. And this is actual, just copy and paste. Yeah. For a technique that I might suspect that the person has not learned or would not be able to receive safely. And remember, the context of this, Tom, real quick, is a black belt instructor with a white belt student. And again, we'll talk about Jack's skill level in a second, but just for context, all of this is being framed in the very specific circumstances of this incident. So what has happened in BJJ, and this is sidebar here, is that people have taken this incident that was very specific and spoken about in very specific terms, and they've taken it and kind of amplified it and said, well, we're screwed in every case now. So I just want to make sure we're clear that this was, for this particular case only, everything was referenced to that, and everyone who was in deposition and in trial understood that. So so for a technique that I have, that has a student has not learned and would not be able to receive safely, I don't proceed with the technique. I ask them to stop. I may be in the moment, and then say, hey, tuck your head right here so that you can roll and don't hit your head on the ground. So those interventions happen in the middle of training sessions to verify that they're capable if I'm not certain that they can receive it safely. Many techniques in jiu-jitsu do not require the recipient, and in parentheses, to know the move, because the pressure and the control is applied so gradually that there's very little risk or concern that the recipient cannot receive the technique and surrender in a safe amount of time. So the smaller margin of response time for the recipient, the more catastrophic the potential injury. Those two variables, the likelihood of a severe injury and response time, the small response time to be able to surrender prior to an injury being sustained, those are the two variables that are essentially the variables that one would ask to ascertain the general or inherent risk of a technique. And the forward flip back take scores highly in the possibility of catastrophic injury, as we now know, and scores very low in the category of time granted the recipient to safely surrender. And that combination of low response time and massive potential for injury is what makes the technique inherently dangerous and why that technique is unadvisable for an expert to apply on a beginner. So what's important to say is, they also asked me, with regards to this maneuver, it's your opinion that this maneuver should have never been done by Mr. Rener? I said, yes, that is correct, particularly by the instructor who was responsible for the safety of the student. Again, if you have two white belts, and this is the important part, who are grappling and they perform a technique on one another because they learned it on some YouTube video, then there's not much we can do to prevent injury. Nor is it the case, Tom, if there's two professionals that are training intensely, accidents happen. So I think the uniqueness of this case was that you have the expert in the room, the black belt instructor, who's the trusted safety advisor, consultant, expert in the room, and he does a technique on a student that the student testifies has never learned and does it in a way that the student did not know how to receive, and it caused injury. So then they made the determination that that created unreasonable risk for Mr. Rener because of the fact that that disparity in skill, but also the intensity with which it was applied and the actual incorrect application.
Now, I hear what you're saying for sure. And anyone who's just coming into this chat, if you guys haven't been watching from the beginning, I would advise you to just wait to comment and go watch from the beginning, because we've covered some of the things we're speaking about already, like the Granby roll. Also, this is not like a debate, right? Like what happened when Rener and I spoke on the phone, there was a lot of misunderstanding. Like a lot of the things that I thought Rener knew or thought Rener did, he didn't know or he didn't do. And a lot of the things that I thought the defense would have in play for common sense, they just didn't have in play. All right. Like, again, they never said anything about a Granby roll. Now, when we talk about the disparity in skill, the difference in skill level, you know, I saw a match of the, what's his name? Green? His last name?
Rener, yeah.
Rener suplexing a kid in a competition, you know. Now, one thing I do disagree with is I don't believe that this particular situation with Rener was totally foreign, right? Like, he's had a lot of wrestling experience, I heard. I think he was a varsity wrestler. I believe that he trained for a few years with Barry Yoshida. I know he's competed multiple times and didn't look like an average competitor. He looked like a pretty strong competitor. Like I said, strong enough to lift somebody and apply a proper suplex, not just a half-assed suplex. Like, he did it perfectly. I can't think that this technique with the arm trapped was so foreign. And again, although he didn't initiate the Granby roll, generally speaking, a wrestler in this position will know to do a Granby roll. Now, here's a problem. If the defense didn't try to say whatsoever that Rener was experienced, that they didn't try to argue the fact that he had years of experience, and you're literally just approaching this as this guy is just a white belt, that's when the waters get mucky, you know. And is that what happened? Is that what happened? Like, they didn't try to say he had experience at all? No,
we spoke extensively about the fact that he had wrestled. We spoke extensively about the fact that he competed as a white belt. And, you know, and I just want to say here that there's so much misinformation and there's so much misclassification and misquoting of the deposition transcripts, Tom, that I put them on my Instagram profile. I want to say it before I forget, for download. So the deposition transcripts, if you go to my Instagram, click download, you can read the whole thing for yourself. So the defense makes it very clear that the guy was they made it clear that he was an experienced white belt. And I said, yeah, you know, and my position was, he's an experienced, I know he competes, I know he wrestled. I actually spoke to Rener, and that wasn't unclear to anyone. That wasn't unclear to the jury. It wasn't unclear to us. It wasn't unclear to the judge. It wasn't unclear to either party that he had experience as a grappling practitioner. So when they asked me, and I classified him, I called him a beginner, right? As someone wearing a white belt, there were really three things that I was looking at. Number one, his instructors had not given him a blue belt, right? So when you just think loosely about jiu-jitsu, white belt is the early, the novice, the beginner belt, blue, purple, brown, black. The second thing was